They said exactly what you said.
What are the specific exceptions that you would identify? Ineffective assistance of counsel.
So that goes to knowing involuntary.
Right.
And then
sentence exceeds the statutory maximum.
Yes.
Right? And unconstitutional factors used in the sentence.
Yeah, I would just call that violates the Constitution. Now,
well, those are three.
No, just two.
Well, I listed three there, but
hold on. Can I combine them into two? So the unauthorized by statute, the problem with the Fifth Circuit is, you could have what that means. You could have restitution unauthorized by statute. In the case of the Eighth Circuit, they applied a lifetime ban on certain things for this gun. It was just unauthorized by the statute. To me, covers a little more than sentences exceeding the maximum. Also, this condition of supervised release, if it was you have to go to church, it's not allowed by statute. And it's plainly unconstitutional.
Well, supervised release conditions, I think, do present a different bucket, and I just wonder,
they do.
How would you characterize what the exception for conditions of
just unconstitutional. You could say it exceeds the statute. The statute is very broad about reasonably necessary. It's just got a lot of yada 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 about kinds of stuff. But when it gets to this kind of stuff, which is just weird stuff, like go to church. Castration seems a little bit outside the statute. One of them said the defendant was getting so many women pregnant out of wedlock. This is a federal court, and said, if you're going to get someone pregnant, can you please make it your wife? You just can't do that. Come on, that's silly.
Counsel, how much of this?
You just can't do that. And that's unauthorized by the supervised release statute.
And then anything beyond that. I just want to have a defined list if we're going to do this.
So what cabins it is the first part. You can't just say, well, I don't want to talk to my probation officer every day because that violates my free speech. You're not even going to get past the first gate. And you're going to run the risk of getting sanctioned. So all that kind of garbage is out.
And then if I could finish.
Sorry.
In your beginning, you said clear legal error. And now that seems to open up, because everyone thinks their legal error is clear, open up a wider box. And I just want to make sure.
So no, because you can say, like, mandamus, clear and indisputable, clearly established, plain error. The error has to be obvious, clear. And that's what the courts below say. You can even say it louder. You get to say what you want.
Well, some courts say that and some courts don't. That's why we're here.
I will be honest, some are really broad and just say any illegal sentence. And guess what? There's no flood. There's no appeals. There's 30 years of this.
I'm not disputing you.
Okay.
These are
I'm
not
sorry.
hostile questions.
So, the thing is, I trust the system on the three systemic reasons because there's an appeal waiver. Yeah. And the Court of Appeals don't want to see these, and lawyers, are very careful in bringing them. On terms of clear error, I do think it's like the second prong of Alano. It's just plain error. It's easy. It's applied every day in forfeiture. No one has a problem misunderstanding that.
Are you essentially endorsing the Fourth Circuit's test, which is a fundamental constitutional or statutory right that was firmly established at the time of sentencing? Is that what you're saying to Justice
Kavanaugh? I like
Kavanaugh?
that. Yeah, that sounds good. I hadn't heard that one, but I just think in terms of Justice.
That's the Fourth Circuit standard.
I'm just trying to get Justice Alito's vote, and what I'm trying to say to Justice Alito is I care about the rest of you too, but
Thank you very much. Very, very few advocates have that.
I'll just stop then.
Goal.
Ms. Blatt.